Hello everyone, welcome back to my channel Study with Neha Mava, and I am back with the another video, and in this video we are talking about a step further in the Indian Contract Act 1872. In this video we are talking about proposal, offer, invitation to offer, some of the illustrations with it. So without wasting time, let's get started. So before that, I welcome you all who are watching my video. Please do like my video, subscribe to my channel and share with your friends. So in today's video, we are starting with the proposal under Indian Contract Act. So what is proposal? Proposal is something that is related to the offer, or we can say proposal is the offer that one person gives or offer something to the other person. So according to section 2 subclause A of the Indian Contract Act 1872, when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of another to such act, he is said to make a proposal. So generally proposal means the offer that is made by one person to the other in reverse of the acceptance by the another person. So proposal must be definite and specific in its terms, or we can say proposal means, for example, A made a proposal to B. So A made an offer to B to give his acceptance on a particular thing. When the offer and acceptance is signified, then it becomes a promise. So here we are talking about the acceptance part. Acceptance means when the another party signifies his assent and tries to willingly accept that offer, it called the acceptance. Once the other party accepts the proposal, it becomes a promise and the terms of the contract bind the parties. So if the proposal is not accepted, it will be mere the invitation to the offer, and that is not legally binding between the parties. Then we have some of the examples here. Let's say a person, a person A offers to sell their car to B for a certain amount. The offer is made orally. Now, the offer has been made orally during the conversation. Now, you can see here A, just a minute. Here, a person called A, he wanted to sell the car to B. Okay. Now, when the A made the offer, he made it orally, right? During a conversation between the two parties. This offer is also a proposal, and if person B accepts the offer, it becomes a binding contract even though it is orally signified. Okay. Then we have another, a company A offers to sell its product to another company B for a certain price. The offer is made in writing and sent via email to company B. This is also called the offer, and when the company accepts it, it becomes a contract. Now, what is invitation to offer? Let me tell you one thing. There's a huge difference between the offer and the invitation to offer. Offer means when the proposal is made or given to a particular person, it becomes the offer. But when the proposal is made to the general public, it becomes the invitation to offer. So here, an invitation to offer is a preliminary communication that invites, generally it invites or encourages someone. It encourages someone to make an offer or proposal rather than being the actual offer itself. It is an invitation to negotiate or make an offer which may and may not result in the formation of the contract. Simply, what I'm trying to say, one we have the offer, another we have the invitation to offer, right? Invitation to offer. When we are talking about the offer, simply when we are just wait a minute. See, I am talking about offer. When I am talking about offer, offer means when the proposal is made by one person to the another specific person, or means offer means when the proposal is made to a particular person, it is the offer, right? But invitation to offer means when the proposal is made not to a single person, but when the invitation or offer is made to the general public in whole, it is the invitation to offer. In simple terms, invitation to offer is the invitation to commence negotiation. In this, the in offer, possibility of negotiation may be lesser, but in invitation to offer, the possibility of negotiations or discussions may be more. And it does not create a legal obligation to accept the resulting offer, right? It fully depends upon the discretion of the parties. So examples of an invitation to offer includes like the advertisement. They are just inviting you, they are not forcing you to do this act. Price list, catalog, display of the goods, window shopping, online store and all, right? Then we have landmark cases dealing with the invitation to offer. First we have Fisher versus Bell, 1961. This case established the principle that display of the goods in shop window or on a shelf is generally an invitation to offer, okay, but not a particular offer. So the customer offer to purchase the good at a certain price would constitute a proposal, and the shop owner acceptance of proposal would form a binding contract, right? So here, whatever the things have been displayed in the shop, that is the invitation to offer. But when a person got attracted and the person makes an offer that I want to buy this thing for a particular price, now it's fully on the discretion of the seller if he wanted to accept that proposal or not, okay? Then we have communication of offer is necessary. Now they are saying that communication of offer is very much necessary. There's a case, Lalman Shukla versus Gauri Dutt. Very, very, very important case. Very, very, very leading case. Now, what was there in the case? I will tell you. Just we have to look it very carefully what this case is all about. So, this case is generally related to the offer or the communication of offer. So, let's go into it. We have Lalman Shukla versus Gauri Dutt. The case name is Lalman Shukla versus Gauri Dutt. It's a very landmark case in the law of contract that deals with the issue of offer and acceptance. Case was decided by the Privy Council in 1930. This means it's a very, very, very old case. Okay, so in this case, Lalman Shukla was the servant of the Gauri Dutt. So far we know that Gauri Dutt is the owner and Lalman Shukla is the servant. Now, Gauri Dutt was the uncle of Lalman's deceased father, right? Gauri Dutt had sent Lalman to search for his missing nephew and had promised to pay a reward of 501 rupees to anyone who could find him. Now, anyone. Gauri Dutt had made a promise to pay 501 rupees to anyone who could find him, but not to a particular Lalman Shukla. However, before Lalman could return with the news that Gauri Dutt's nephew had been found, Gauri Dutt learned of his nephew's death from the other sources. Okay? Gauri Dutt then refused to pay Lalman the promised reward, claiming that the offer of the reward was made only for the purpose of finding his nephew alive. Now, finding a particular person, whether alive, whether dead, does not have any relation with the offer or the communication of offer or the price reward. So Gauri Dutt then refused to pay Lalman the promised reward, claiming that the offer of the reward was made only for the purpose of finding his nephew alive. and that since his nephew was now dead, there was no offer to be accepted. This was the contention of the Gauri Dutt. Now, what the court held? The court held that there was no contract between the parties, whether it is a Lalman Shukla or the Gauri Dutt or anyone else. Court found that Gauri Dutt promised to pay the reward was an offer, and that Lalman's search for the nephew was the acceptance. And the court noted that an offer can be accepted by performing the requested act that Lalman Shukla has done, and that Lalman's search was a performance of the requested act. So court rejected the contention of the Gauri Dutt argument that the offer was only for the purpose of finding the nephew alive. The court explained that offer was not limited to finding the nephew alive, but for the act of finding the nephew, whether alive or dead, as I told you earlier. So the court found the Lalman had accepted the offer by performing the requested act, and the Gauri Dutt was bound to pay the promised reward, right? Then we have types of offer. We have different types of offer or proposal here. Firstly, we have cross offer. A cross offer occurs when two party makes identical offer to each other without knowing that other has made an offer with the same contention. In such a situation, neither party can accept the other's offer, as there is no clear indication of the intention to create a legally binding agreement. Cross offer means when there are same terms and conditions of both the parties, and that crosses the both offers. So we have this one case, Tin versus Hoffman, 1873. In this case, the plaintiff and the defendant were negotiating the sale of a quantity of tin. Plaintiff sent a letter offering to sell the tin at a certain price, and the defendant sent a letter in response also offering to buy the tin at the same price. Now, same terms and condition, everything is same between the parties, so the offer will be crossed. Neither party had received the other letters at time they had made their offer. The court held that there was no contract between the party because neither of the party has accepted the other's offer. Then we have counter offer. Counter offer is a response to an initial offer that varies the terms of the original offer. It is essentially a rejection of the original offer, and it terminates the initial offer. Counter offer means, for example, A wanted to sell something for 50,000 rupees, right? B wanted to purchase it for 40,000 rupees. Now, B will make the counter offer for 40k, okay, but will not accept that initial offer of 50k. There's a case of Hyde versus Range, 1840. In this case, defendant offered to sell his estate to the plaintiff for a certain price. Plaintiff made a counter offer for the lower price, which the defendant rejected. The plaintiff then attempted to accept the defendant's original offer, but the defendant refused to sell. Court held that there was no contract between the parties, so plaintiff counter offer amounted to a rejection of the defendant offer. We have specific offer and general offer. Simply means, specific offer means when the offer is made to a particular person or to an individual, it is called the specific offer. That is the normal proposal. General offer means when the offer or proposal is made to general public at large. It is the invitation to offer. So specific offer is an offer made to a specific person or a group of people. For example, if a person offers to sell their car to a particular individual for a certain price, this is a specific offer. Specific offers can only be accepted by the person to whom they are addressed. If the offer is not accepted, then it is not a contract. And general offer, public at large. Then we have standing offer, open and continuing offer. In contract law, offers can be classified into different types based on their duration and the ability to be accepted. We have the standing offer. A standing offer is an offer that is made to a particular person or a group of people and is valid for a specific period. Let's say 1 year, 6 months, whatever it is. It is a type of specific offer that remain open for acceptance during the specified period. If a company offers to sell a particular product to a specific person or a customer at a fixed price for 1 year, everything is specified. Standing, it is a standing offer. Open offer means when it is open to the public, general public, and there is no time limit and foundation. It is the open offer. Then we have continuing offer. Continuing offer means that remain open for a specified period but can be accepted multiple times during the period. If a company offers to supply a particular product to a customer at a fixed price for a period of 1 year. Now, customer can place the order twice, thrice, how many times they want, but only that in that 1 year span time. So it is important to note that legal implication of these different types of offer can vary. For instance, a standing offer can only be accepted by the person or group of person to whom it is addressed. An open offer can be accepted by anyone who meets the specified condition with a reasonable period, while continuing offer can be accepted multiple times within the specified period. Now, here the period must be specified. Then, this is the end of the video. I hope you understood what I discussed with you all today. So, if you want something to know about, please comment below so I can read your comments and I can solve your problems. So, thank you so much. Please subscribe to my channel, like my video, and share with your friends. Have a good day.